sovereignty when no one else would. And I did it nearly alone, and I did it at great personal cost. That's the truth. That's what happened. The Supreme Court, in 48 hours after the case was submitted, in 6 short sentences, said, no, Texas, you can't sue Pennsylvania. That's a professional embarrassment. It means this isn't a hard legal question. Many of the Supreme Court's cases go on for pages. This one was 6 sentences in 2 paragraphs. It said, no, you don't have standing. No, in essence, California, Washington, you can't sue Idaho for Idaho's exercise of its sovereign power. Now, I have on numerous occasions sued the Biden administration. In fact, I was the one who sued the Biden administration over the vaccine mandates. We were able to take 2 of those already to the United States Supreme Court on the OSHA case. We won that case. Actually, what we won was the court issued a stay against the enforcement of the OSHA vaccine mandate. We didn't actually win the case outright, but we went back down to the Court of Appeals, and the Biden administration wanted to continue litigating that, and we said, look, the court already said you're going to lose. So the governor and I then, with some of our colleagues across the nation, prevailed upon OSHA to just stop that rule. And that rule is no longer in existence, and that vaccine mandate is gone. We weren't quite as successful on the CMS mandate. That's the Center for Medicaid and Medicare and Medicaid Services. The court did issue a stay in that regard, but we are continuing to litigate that in the lower court. We also filed an action on the federal contractors. And how is that? Well, if you think about it, the state universities are federal contractors, but they're also state entities. So we brought the action and said, you federal government don't get to order state entities what to do. And so we are continuing to litigate that case. There's been a lot of discussion over this campaign about, well, what's the Attorney General supposed to do? So let me help you understand what the Attorney General is actually supposed to do, as opposed to what people think the Attorney General is supposed to do. As the Attorney General, my job is to represent the state. Some people take exception to that and say, oh, you choose to represent the bureaucracy. No, I don't choose to represent the bureaucracy. That's what the law says. In Idaho Code Section 67, 1401, it says the Attorney General shall represent the state and state agencies, and then it names them, boards, commissions, on a whole variety of things. It says you, Attorney General, represent the state. That's my job. It says you go to court on their behalf and you give them legal, not policy advice. That's what it says. Now, Idaho Code Section 67, 1406 also says, and by the way, when the governor asks you, you're required to provide him legal services, give him legal advice, and represent him in court. As an attorney, you don't get to undermine your client. When you hire an attorney, your attorney doesn't hold a press conference and say you made the wrong choice. Your attorney doesn't get to sue you and say, hey, I don't like what you're doing. It's the very same thing that I have to do. When I'm the attorney for the governor, my job is to give him legal advice, and it is to represent him in court. I cannot violate my fiduciary duty as an attorney simply because he may disagree with me.
But you can violate your oath of office to the Constitution? It's his time. Thank you.
And the answer is, my oath to uphold the Constitution is doing exactly what I'm elected to do. Let me tell you what the Constitution says. The Constitution says the Attorney General has the duty to perform his constitutional function, which is to sit on the Land Board and the Board of Examiners, and the Constitution says to perform my duty as provided by law. That's what it says. That's my oath. That's my responsibility. And I've just explained to you what the law says I'm supposed to do. exactly what the law says, which is precisely what I've done. Now, some have said, well, you should sue the governor. The answer is, I don't have the legal authority to do that. I am not the king. No one appointed me king, no one elected me king. I don't have the authority to usurp the governor's authority. He makes his decisions. My job, if I can make a legal defense of his decision, whether I agree with it or not, my duty as his attorney is to make that legal argument in court. Just like your attorney does for you. It's the same duty and responsibility. Does that make sense? Yeah. Sheriff, you had something?
Yes, sir. So your definition is that who represents the people of the state of Idaho?
So, well, I'll tell you who that is.
Could you repeat the question?
The question is, well, who represents the people of the state of Idaho? You elect a governor, and you elect members of the legislature, and they're the policy makers. That's not what the Attorney General does. In fact, when you read the statute and understand how a statute is defined, the statutes I've given you, 67-1401 and 67-1406, and it says that I'm to represent the state, it means I don't represent you as an individual. I represent you collectively. That's what the law says. Who represents the people? The governor represents the people. The legislature represents the people. You elect them to represent you to do that. I'm elected to do what the Constitution says I'm supposed to do. And I'm telling you, that's what it says. Look it up. You can look up Idaho Code Section 67-1401 right now. And it will say exactly what I told you. That's the job. A lot of people misunderstand what the responsibility of the Attorney General is. I do exactly what the law requires of me. Now, there's recently been kind of a scurrilous story that I know is on somebody's website about me and about an incident that occurred in North Idaho concerning Carol Asher. Let me address that, because I asked you if you believe there were at least two sides to a story. And there are at least two sides to a story. So let me give you the rest of the story. What happened is there was a woman, her name was Carol Asher. She was selected to be on a jury in a criminal trial. It was a drug trial. And she got on the jury, and the case was tried. They went into the jury room, and she told the other jurors that she had lied to the judge in order to get on the jury. She lied because she didn't like the way the law operated, and she wanted to make certain that she got on the jury. So that's what she did. She told the other jurors that's what she had done. Well, those other jurors told the judge. And after the case was over and there was a hung jury, then the judge contacted the prosecutor. And the prosecutor then contacted us and said, we have this serious concern. I got the letter from the judge. And they said, yeah, we're very concerned. We're concerned that she would openly lie to the judge. Remember that jurors are taken oath as a juror to truly try the case based upon the facts of the law. So we took a look at the case, and we had an investigator who interviewed all the folks, and we did exactly what we're supposed to do. That is, we take that evidence, we put that evidence in front of a court. The court makes the determination whether there is probable cause or whether there isn't. I don't make that determination, a magistrate does. In that instance, the magistrate made the determination that there was not probable cause. So what did we do? We did exactly what we're supposed to do. There's an order by a court that says you, Attorney General, are the special prosecutor in the case. We went out, we got the evidence, we put the evidence on in front of a magistrate, and the magistrate says it doesn't constitute a crime. That's the truth. That's the other half of the story. That's the part that other people haven't really paid any attention to. So, let's talk about some of the things that I have done. In the last year, my budget was about $26.6 million. I returned $44 million to the state of Idaho. That means for every dollar that I was appropriated, that means budgeted by the legislature, I returned $1.66. How many agencies do you know of that can say that? I returned about $7.25 to Idahoans on consumer protection issues. That is, for every dollar I got, I gave you, I was able to get for you at $7.25. We got $22 million on the tobacco settlement. That's ongoing litigation that we have. It's the 1998 Tobacco Master Settlement Agreement. We litigate on that every year, and we return about $25 million that goes to the State Millennium Fund. In ICAC, the Idaho Idaho Crimes Against Children Unit, what they do is they investigate crimes against children. When there will be a person who will try and entice a child on the internet, we go after those people. Just this past year, we received more than 1,500 cyber tips. We opened 875 cases, and we made 58 arrests. That's what I do as the Attorney General. I care about your kids. That's how I represent you. As the Attorney General, as I've tried to explain to you, like it or not, the Attorney General's job, under the law, is to represent the state. That's what I do. Thank you very much. If you have some questions, I would be glad to entertain them. Yes.
You filed an advisory opinion that said biological men have a constitutional right to join women's athletic teams. Why do you think biological men can take the place of a woman?
Biological men cannot take the place of a woman, and I did not issue an opinion that said that. What I said was that, hold on for a second. Hold on for a second. I issue opinions. The statute says that I have to answer the question of a legislator, okay? And I got a question. Will that bill be constitutional? It isn't, do I think men are better than women or men can replace women? It's not on the issue of whether I agree or disagree with the subject. The question is, will that bill pass constitutional muster? And I have to look into a crystal ball, and I have to try and guess what will the court say. And given the cases that were in existence at that time, the answer was, I don't think it will pass constitutional muster. That doesn't mean that it shouldn't be passed. It just means I don't think that we're going to survive a constitutional challenge. Why is that? Here's what I do. When my job is, as I describe it, you and I driving down the street in a car. We look up there, we see a traffic signal. I notice that the light is red. You ask me, what color is the light? I have one of two answers I can give you. I can tell you the truth, and I can say the light is red, and you get upset and you say that's simply because you're a red light lover. Or I can lie to you, and I can tell you the light is green. And you slap me on the back and you say you're a great patriot. Here's the problem. If I'm willing to lie to you, it doesn't change the color of the light. The light is still red, and when you go through the intersection, you're going to get hit. Now, others have said, well, what if the light is yellow? And then my response is, then I tell you the light is yellow. Proceed with caution. That's the whole point. My opinion is not whether it should be passed or shouldn't be passed, whether it's good law or bad law. That is not my opinion. My opinion is what's the law, not is this good legislation. Have I answered your question? I don't disagree with you. But my job is to say, is it a good piece of legislation or a bad piece of legislation? My job is to say, will this pass constitutional muster or will it not? It isn't to say it's good or bad. I don't happen to agree that men should participate in women's sports. That's not the question that I have in front of me. It is, will this pass constitutional muster? So you're mischaracterizing what the nature of a legal opinion is versus what a policy opinion is. Okay.
Okay, you say you're a lawyer for the lawyers. You talk lawyer talk. We want to hear what common talk you talk. Tell me 7 things that you've done for the state of Idaho for people like Coeur d'Alene, Idaho. Don't give me this lawsuit judge law for the Supreme Court, get down to our level and say, what have you done for us here in Coeur d'Alene?
Well, I've actually given you 7 things.
Well, I want to hear.
Well, then I'll remind you of what I've said, okay? Number 1, I chose not to join Texas versus Pennsylvania.
I don't care about that.
You asked the question.
Okay. Let's
But
let the attorney general.
this is locally. This is your sovereignty. This is your ability to make your own decisions. You were just talking about that a second ago. I did that for the state of Idaho because that's what my job is. I also protected your children. Did you know that in Post Falls a couple of years ago, I was making a presentation on the internet crimes matter. A young girl at Post Falls school, it was the middle school, came up to me and she said, "Oh, I'm in internet contact with a man in Texas who was driving to Post Falls to meet that 13-year-old girl." We got our parents involved, we got the police department involved, and we arrested that guy. So you asked me what I've done for you? That's what I've done for you. I told you that we've had 1,500 cyber tips. We've had 850 investigations and made 58 arrests. Who's that for? That's for you. So, yes, I have told you 6 or 7 things that I have done for you. We got a question over here. We got over here. Microphone's over here. I don't know where it is. Yes. Okay. Whoever it is.
Okay, yes, I have a couple questions.
Okay.
First, on April 21st, 2020, an Idaho citizen, Sarah Brady, was arrested in Meridian, Idaho for misdemeanor trespass while at a public park with her children. Your office is lead in the prosecution of this woman. 2 years later, this case is still pending. If you are re-elected as Idaho State Attorney General, can we expect more of this type of punitive prosecution and civil rights violations by your office to continue? That's the first half. Let me get the second half here.
Can I address that first?
Okay?
The answer is this. I acquired that case by special prosecution. It's not that I went out looking for that case. That case came to me. In fact, there's a court order that says you shall prosecute this case. That's the reason I have it, okay? Because we typically don't do those kinds of cases. So the question is, am I willing to fulfill my duty as a prosecutor? And the answer is yes. Now, what you've recited as the facts of the case, I can tell you are not the facts of the case. Now, I can't discuss the facts of the case because I'm prohibited from doing that by the law. The special rules that apply to prosecutors say I cannot make an extrajudicial statement or allow one to be made that would prejudice the jury. And so we can't talk about those facts. That's the law.
So
Okay, what's the second half of your question?
2 years later on a misdemeanor charge. Thank you.
And the answer is, well, let me address that. You've asked the question. Let me address it. You've asked the question, let me answer it. I'm not the one who has delayed that case. We've been ready to try that case from day one. We are not the ones who've made a delay of the case at all.
Sir, can she answer the second part? Or ask
She can now ask the second part.
Okay, your office conducts training on open meeting laws and public records. I was lucky enough to attend one of these sessions several years ago. Within this training, you encourage agencies to work with the requesters on public record requests to get the information that they're seeking. I have repeatedly requested trespass cases that your office has prosecuted in the past. These requests have been repeatedly denied. Records and data are kept on pretty much anything and everything in the world today. I find it hard to believe that in the year 2022, that this information is not readily available from your office. Again, if re-elected as AG, what will you do within your office to increase transparency in fulfilling public records requests made to your office?
We are extremely transparent. The answer with regard to your the trespasses case you're talking about, we don't typically prosecute trespasses cases. The only one I know of is that one.
I can't get it through public records, can
You can't get public records that don't exist. You can't get public records for that case because disclosure is prohibited by the Public Records Act until the case is closed.
I've got all the correspondence from Jeff now.
Excellent. Well done. Then you actually have it, don't you?
I've got it.
Oh my goodness.
All right, I think.
One more.
Okay, one more question.
So, that's your concern?
I can hear you.
Does the First Amendment protect obscene and pornographic material under the guise of sexual education? Being purchased and procured and displayed to elementary school children in Idaho? In libraries. But if not, then why did you file an advisory opinion that said it would be unconstitutional to remove the obscenity exemption that allows filth into our taxpayer-funded elementary school?
Let me address something first of all. Several of you have addressed this as an advisory opinion. It's not an advisory opinion. It is a legal opinion. The question is different. I'm not giving the advice to the library. The question is there a First Amendment issue? And the answer is yes. There is a First Amendment issue. I'm not telling your library board what to do. They make their own choice. I'm not giving them legal advice. When I'm issuing an opinion, it is what is the law? And that's how we deal with that. Do I believe that pornography should be given to children? No. In fact, I just talked about the fact that internet child sexual, most of that is pornography. You think about a pornographic image of a child, that's not just entertainment. It isn't entertainment. What it is, it's a photograph of a crime scene where a child is being abused. And we arrest those people and we put them in jail. So that's my answer to your question. All right? Thank you very much.